page.
Okay, George.
Are we on YouTube?
Yes, ma'am. It's showing me it's streaming here, but it's not giving me an indicator on the.
There it is.
There you go.
You. Good morning. This is Judge Alyssa Perez presiding over the 210th District Court Civil Docket for May 21st, 2025. All matters being heard today are being heard in accordance with all directives regarding remote proceedings. In addition to that, we are streaming all matters live via YouTube for public viewing. I'll go ahead and call our first case. Bear with me. Calling cause number 2024 DCV 4268, Yasmin Dominguez versus Javier Castañeda Valles and Isleta Independent School District. May I have announcements, please?
Mario Jag on behalf of the plaintiff, Your Honor.
Kurt Paxson for the school district.
And this is, I apologize to you, gentlemen, because this is something that I'm seeing the notice of hearing that was filed back on April 16th, but I don't know if there's a glitch in the system. It wasn't actually on our docket, so I'm glad you all are here. I have a plea to the jurisdiction. Let me just pull up what I'm seeing is an amended plea filed on March 21st. Was that the only thing that we were anticipating being heard today? Because now I'm seeing also there's a motion to dismiss. What was set for hearing today?
The amended plea to the jurisdiction, Judge, which is in a way a motion to dismiss.
Okay, gotcha.
That's the relief requested.
Okay, bear with me. I have a printed copy of defendant's reply.
Yes, Judge, there was a real poor copy of a statement from the plaintiff. We want to make sure you could see that. I couldn't make it any lighter.
Okay, so here my amended now. I have the Odyssey amended plea to the jurisdiction. All righty. All right, Mr. Paxson, you may proceed.
Judge, this is a dispositive motion similar to a summary judgment proceeding. The school district is immune from liability and also immune from suit. And so a plea to the jurisdiction is allowed if they do not meet the notice requirements. The statute requires that you give notice to a political subdivision within 6 months of the accident. And there's very specific requirements in the case law. If you just look at the statute, it doesn't really inform you. You have to look at the case law that tells you exactly what information must be delivered to the political subdivision in a timely manner. Judge, before we start on the merits of the action, similar to a summary judgment proceeding, our reply includes a motion to strike. Attached to the plaintiff's response to my plea to the jurisdiction is a letter, without more.
Mr. Paxson, if I could stop you right there and let me just check in with Mr. Yage, and I just need to catch up as I'm kind of going over these documents for the first time, frankly. I am seeing plea to jurisdiction. I am not seeing the response. Was the response? Oh, there we go. It was filed on May 13th.
Yes, Your Honor.
Okay. Let me pull that one up really quickly, okay? Because I feel like I don't have everything in front of me just yet. All right. Okay, go ahead, Mr. Paxson. I apologize.
And so, Judge, if you look at that response, attached to it's a letter, without more, just a letter. It's not proved up. And so, similar to a summary judgment proceeding, you can't just start attaching documents. You would need an affidavit to authenticate it. And here's the problem, Judge. That letter, the first time that we ever saw it was when it was attached to that response. It was never received by the district or by Sedgwick. And there's an affidavit in our reply demonstrating that. In the reply, Judge, there's actually more than one claim note back in 2022 and 2023 stating that they're talking to the claimant. Well, think about that. If we knew that she was represented, would we be talking to the claimant? Of course not, okay? But there are specific claim notes saying we've never received a letter of representation, and that's why we're talking to her. And then in May of 2023, she actually makes the representation, I'm not represented, okay? She doesn't even have an attorney. So we did receive in 2024, which is crazy late, it can't possibly meet the 6 months requirement in the Tort Claims Act. We did receive a letter from the Herrera law firm, and then the suit issued. And then for the first time, we see this letter that supposedly was issued back in 2022, but Judge, it was never received, and there's no one to authenticate it to say it was ever sent.
Okay. Look, can I stop you right there? I see the request in your reply yes, to the plaintiff's response. Mr. Yage, on the motion to strike, do you have any response for that?
Yes, Your Honor. I can't provide an affidavit because the person that wrote and sent the letter no longer worked for the Herrera law firm, and they were unavailable to corroborate that they in fact sent the letter. But I think the issue here is a bit broader, Your Honor. Simply, as Mr. Paxson stated, he provided an affidavit from a claims representative of Sedgwick stating that Sedgwick never received the letter. But the issue here is whether the Isleta Independent School District had actual notice of a claim that would move forward to give them enough time to prepare for ongoing litigation. And that's the heart of the issue, Your Honor. So that letter that Mr. Paxson, an affidavit, that he attached to his reply, I think goes to a different issue, which is whether Sedgwick had notice, which isn't the standard here.
Well, Judge, I'm just looking for a ruling on the letter itself, the motion to strike.
Right. And so Mr. Paxson is asking that letter be struck from your response for want of authentication. So is that the extent of your response to that?
Yes, Your Honor.
Okay.
I will concede to that.
Okay, so yeah. So we'll go ahead and grant that request. The letter attached to plaintiff's response is stricken.
And Judge, may I submit a written order to memorialize the court's ruling on that?
Yes, sir.
Okay. Judge, now, we now turn ourselves to actual notice and what is required for actual notice. The jurisprudence on this is very clear. You have to have better notice than just something that would say that you were injured. But Judge, here, we took the deposition of the plaintiff, and I repeatedly asked her about her conversations with the school bus driver. For instance, if she had told the school bus driver, who's now deceased, that she was injured, that might be a fact issue. Again and again, we walked through the conversation she had with the school bus driver. She never told him that she was injured. She never talked to anybody thereafter and said she was injured. And Judge, importantly, in that reply, we attach her, admittedly, it's a poor copy of it, but it's legible, I believe. And there she's talking about how the accident happened. And if you read that from top to bottom, nowhere does she say that she was injured. And so, Judge, again, this was never set up as a bodily injury claim. This was set up as a property damage claim and was denied because this is a liability issue, okay? It's an intersection collision, and there's a sort of a swearing match as to who jumped the stop sign and who had the right of way. But in any event, talking today about notice alone, we did not have notice of a bodily injury claim. She never told us about it. And so the 6 months came and went. And during this interval, Judge, ironically, we're talking to the woman. I mean, she's providing us information. She didn't have collision coverage on her car, and so she was asking the district to pay for the damage to her vehicle. And so the conversations and communications are percolating, but it's never about a bodily injury claim. And so, Judge, there's simply no evidence that they gave us the kind of notice that's required. They cite to one Supreme Court case, the Worsdale case. I wanted to talk about that for a second, Judge. In Worsdale, you had two people, Worsdale and King. They're on a motorcycle, and it's nighttime, and they're on an unlit paved street that has a great big mound of dirt on it. They hit that mound of dirt, and they're both killed. it's a case against the city of Killeen, and the Killeen Police Department, who are agents of the city. You know, if the police department has actual notice, that's notice to the city. The city police department went out there and investigated, and they had their special traffic unit because it was a death case and everything. They knew these people had died, so the extent of the injuries is pretty clear. They're dead. Number two, they concluded that the mound of dirt was one of the causes. That and the motorcycle driver was intoxicated apparently, but the mound of dirt was a proximate cause of the accident. And so the Texas Supreme Court said in that case, they had actual notice because their police department had located the thing, had said it was the cause of the accident, and they had all the information they need in order to evaluate liability. That's completely different than what we have here, Judge. There's no school district police officer that investigates this accident. And importantly, Judge, in paragraph 4 of our amended plea to the jurisdiction, we lay out the case law, and it's pretty tough, surprisingly tough. It says a governmental unit's awareness of an accident without more is not sufficient to satisfy the notice claim. Notice of a claim for property damage does not equate to actual notice of a personal injury. And we have a string cite on that. A notice that somebody got hurt doesn't satisfy the requirement. It must reasonably describe the damage or injury claimed. And then there's a couple cases in which they specifically state that even if you got a letter of representation from an attorney saying that their client had, representing a client for injury sustained, that doesn't meet the standard for actual notice under the statute. So again, Judge, it's a strict standard that must be honored. That notice had to be given in 6 months. The letter's already been stricken. There's simply no evidence before the court that any actual notice was received by the Sled Independent School District or its agent, Sedgwick, who was handling the property damage claim, that this woman was claiming a bodily injury claim. And so, Judge, we believe the case has to be dismissed for that reason. This is one of those cases or situations, Judge, where whoever's aggrieved by the court's ruling on this has the right to immediate appeal. It goes straight to the Court of Appeals from here. But we don't think there's there is no evidence that we had actual notice of a bodily injury claim.
All right, Mr. Yagan?
Thank you, Your Honor. And I think Mr. Paxton lays it out pretty well as regard to the case law, Your Honor. He mentioned that formal notice is not the only way to give notice to the governmental entity. As long as a governmental entity had actual notice, which gives them ample opportunity to gather information and investigate the claim, then that is sufficient to maintain the claim against it. In this instance, Your Honor, there was a letter sent 9 days after the date of the crash. And while Mr. Paxton made it abundantly clear that Sedgwick, the insurance company, is alleging they did not have notice of the claim, we do not have information on whether the school district conducted any investigation, gathered any facts, spoke to its driver, or spoke to my client for that matter, Your Honor. We have sent requests for production to the Sled Independent School District to gather more information on whether, in fact, they had notice or any type of information that would constitute actual notice that a claim would be ongoing with regards to the crash. I think at this time, the plea to the jurisdiction is a bit premature because discovery is still ongoing on this very issue to determine whether someone at YISD had actual notice of the claim. I think solely because Sedgwick did not have notice of the claim or is alleging the same, that is not sufficient to dismiss this case, Your Honor. I think there was video of the crash, and there was some communications between my client, the police department, and the city, and the Sled Independent School District to determine who was at fault. So there was some investigation going on after the crash. So there is some evidence that they had actual notice of the claim, Your Honor. And I think my client needs to be able to be given some time to investigate that further to determine whether or not there was actual notice. And if at that point in time, the evidence suggests that there was no actual notice and that Mr. Herrera's law firm did not provide formal notice to YISD, then I'm happy to concede to the plea to the jurisdiction. I just think that this is a bit bit premature.
Okay.
Okay. Judge, a couple things about that. First off, notice to the police department, the El Paso Police Department is not notice to the Atlanta School District at all. Okay, those are two completely different entities. We would agree that there was an investigation as to the accident and who caused the accident. But that does not equate to notice of a bodily injury claim, and that's what we're here talking about. I'm not, as far as the property damage claim, Judge, I'm not asking for a plea to the jurisdiction on that, but I don't think it's really within their pleadings. I'm talking about the bodily injury claim. The plaintiff did not give notice to anybody that she had a bodily injury claim. And that's where we are. And Judge, at her deposition, I'm just telling you, I closed the door on that. I wanted to make sure that there was no way that she could come to this court and say, oh, I just remembered a conversation I had. I asked her again and again, did you have talk with anybody else? Did you ever call the Atlanta School District or the people at Cedric? Did you ever tell them anything else besides what you told me today? No, that was it. She never mentioned a bodily injury claim. And that's why the plea to the jurisdiction has to be granted.
Okay.
And Judge, that's what my client stated based on her recollection almost 3 years after the crash. But the issue here is whether the Atlanta Independent School District had noticed, not whether my client remembers telling them about her bodily injury claim 3 years after the fact. So we need to do a further investigation, conduct depositions, get production, get documents to determine whether or not they had some sort of notice, not just a statement from the Cedric Claims Adjusters that they did not receive a letter.
Judge, the Cedric people were the agent for the Atlanta ISD in investigating this accident. They were in communication with the plaintiff. There was direct communications going on. And they say they never had notice of a bodily injury claim. And so again, Judge, the burden of proof is on the plaintiff. And I cite to that in my my amended plea to the jurisdiction, as far as who has the burden of proof. Well, the cases are cited there, Judge. But again, the plaintiff has the burden of proof to show that they had notice, that they gave notice of a bodily injury claim. And as we sit here today, there's simply nothing like that before the court. There's no evidence of that.
Thank you, counsel. I understand your arguments. I'm just a little hesitant in this moment because I haven't fully reviewed your pleadings. I'm sure you've explained them very well today, but I do want to look at some of the cases. So I will have something for you before the end of the week, but I do want to review these pleadings and some of the case law, okay?
Yes.
Anything else you have for today on your case?
No, Judge, I will submit a very bare bones order just as far as the memorializing the court's ruling on the motion to strike.
Thank you very much. Yes, it won't take me long. Thank you, gentlemen. If you don't have
Thank
any,
you, Judge.
y'all are excused, okay?
Thank you, Your Honor. Have a nice day.
You too. Who's next, Mr. Nunez?
Judge, on page 2, second case, let me bring in Mr. Pierre, Mrs. Aguilar.
Can we hold off on that one first? I see Mr. Kennedy. Is he here on Piper Laurie or is it on something else?
Mr. Kennedy is here on 2837, but there's no one here from the defense.
Mr. Roncone's here. I just saw him. It's
Yes, good morning. Carlos Rincon for the defense. This is in the Aguilar versus Saddle Up Express case.
Oh, okay.
Where is that, Mr. Nunez? I found it. Wow. It's already 11. Let's go. Cause number 2024 DCV 2837, Isis Gabriela Aguilar et al. Versus Julian Garland Contreras et al. May I have announcements, please?
James Kennedy for the plaintiff.
Carlos Rincon for the defense, Your Honor.
Scheduling status conference. Gentlemen, are you ready for a trial date?
We are not. We've been had depositions scheduled. They had to get I guess canceled. I think one of associates of Mr. Rincon left. So we got to finish depositions first, but I'm sure we could set the trial based on the court's availability sometime in the December to February range, but I don't know when you're setting trials. So,
Your Honor, yeah, just real quick, we had actually filed a motion for summary judgment on this case based on the video of the crash, but Mr. Kennedy wanted an opportunity to depose a company representative, the driver. And since he's doing depositions, I wanted to depose the vehicle occupants and plaintiffs and their parents, because they're young people driving a car. So we figure once we get those done, then I would respectfully request a trial setting in like February 2026. And and the reason, Your Honor, as Your Honor knows, I'm actually going to be in Your Honor's court for what looks to be all of July and most of August in the Cabral case. And I am just set for trials backed up in the fall already, including in federal court in New Mexico. So a February trial date would work.
So gentlemen, you are both a little more ambitious, I guess, than I was gonna. I was gonna give you May 15, 2026, but I can give you February. I can give you February 2026.
Your Honor, May is my son's graduating from college, and I know, that'd be difficult.
Well, you both said February, so you got it. It's February 20th, 2026.
Thank you, Your Honor.
Thank you, Your Honor.
So anything, you all know the drill, scheduling order, get it back, anything outside of those dates, just request your hearing, pick a mediator, we'll be good to go.
Yeah, we
Your
worked
Honor.
well together, Your Honor. We got it.
Yeah, let me see here. I was just,
Mr. Rincon, I'm a little worried because you said you're gonna be here on that trial August and July. I was
Well,
just expecting July. No,
40 depositions, Judge.
I got
And that's not all the witnesses, just the ones that were deposed.
all right.
Bring a lunch pail.
You're going to settle, Carlos. Come on.
I don't know. We'll see. All right, Judge. Great seeing you, Your
Okay.
Honor.
Good
Everybody
seeing
looks
y'all.
great. Okay, take care.
Thank you,
Bye-bye.
Your Honor.
Thank you. All right. Yes, I want to save that one, Mr. Nunez. So let's,
ma'am.
we get to that one. Let's get rid of some of these that are a little more simple.
Yes, ma'am. On page 2, bottom of the page,
Mm-hmm.
calling cause number 2024 DCV 4936, Laura Lopez versus Hardy Hole Drilling LLC et al. Announcements, please.
Good morning, Judge Calmandel for plaintiff.
Good morning.
Judge Sebastian Uribe for the defendants.
Good morning. Scheduling status conference. You all ready for a trial date as well?
Judge, we're ready for a trial date. I've taken the deposition of the defendant driver. We have all the remaining depositions set. The case has already been mediated and my experts are designated. So if we could get one by the end of this year, I'd really appreciate it.
Oh, Mr. Mundell, the end of this year is not going to work, but I will give you January 23rd. Everybody.
That's perfect, Judge.
in a
I'll
really
settle
good
January
January
mood.
23rd works for us here.
I'm sorry?
January 23rd also works for us, Your Honor.
Okay, there's your trial date. You know the drill as well. Scheduling order, return it, anything outside of those dates, pick them. Oh, you said you already mediated. Who'd you mediate with?
This one was with Mitch Moss.
Okay. Thank you so much. We'll see you next time. Get your scheduling order back to us. Take
Thank
care.
you, Judge. Have a good day.
You too.
Excused?
Yes, thank you. Who's next?
Thank you.
Agnes?
Page 3,
Uh-huh.
calling cause number 2024 DCV 2714, Gerardo Dominguez versus James Patrick Zubia. Announcements, please.
Ariana Ortiz on behalf of plaintiff.
Alejandra Connolly on behalf of defendant.
Good morning, ladies. Also scheduling status conference. Now, you've already heard a few trial dates. Are you all ready for a trial date?
On this one, Your Honor, I don't think we are. We're still in the middle of conducting written discovery.
So what I would like to do, since we're set for a scheduling status conference, unless you're telling me, you know, we're probably 60 days out from settling this, I give you a trial date. We work with the slate of dates. You get my scheduling order back to us, and we're on track. At least I reserve your trial date. So that's what we're going to do. Do you all still have, like, is a February, March trial date realistic, or do you think you need more time than that?
I think a March trial date is realistic on our end, Your Honor.
I think that could work.
Okay, so we'll do March 20th, 2026. And again, you know, just return the scheduling order. You'll have a setting at a 3 p.m. setting in about 2 weeks. That's the deadline to submit the order. Include your agreed to mediator on that order. And then we'll have our slate of dates. Anything outside of those dates, please request your hearing along with your filed pleading with Ms. Hernandez, and we'll be good to go.
Yes, Your Honor.
Thank
Sound
you,
good?
Judge.
Thank you. Ladies, if you
Thank
don't
you.
have anything else, y'all are excused.
Thank you, Your Honor. Have a good day.
Two. Who's next?
Page 3, Judge. Calling cause number 2024 DCV 2551, Melissa Murphy versus Monica Acevedo. Announcements, please.
Steve and Lucy on behalf of the plaintiff, we're ready to proceed.
Linda Samples on behalf of the defendant, also ready to proceed.
Council, we also have scheduling status conference. I've already thrown out 3 dates. So which one do you like? January, March, April, unless you're telling me things are all resolved and fabulous.
I believe this is close to being resolved, Your Honor. The plaintiff would ask for a January hearing.
A January trial setting? Sure.
Yes. Yes.
Okay, Ms. Samples, that'll work, January 23rd?
Yes, Judge.
Okay, if you all will, same thing, get the scheduling order back to us. You'll have your trial date. If it's disposed of before then, great. But good luck. Unless you have something for me, you all are excused.
Thank you, Judge.
Thank you. Who's next?
Judge, on page 4, bottom of the page, calling cause number 2024 DCV 2909, Well States Health Care LLC versus Neuroscience Resources et al. Announcements, please.
Good morning, Judge Perez. My name is Stephen Engelhart, and I represent Wealth States Healthcare LLC, the plaintiff in this proceeding.
Good morning.
Good morning, Your Honor. Mary Jo Vida. I'm here in place of Robert Knable, and I represent Mesa Hills Specialty Hospital.
Okay, I have a notation here. Good morning, council. I have a notation status for pending parties, and we don't have future settings. Wow. Where are we? How about an update?
Update, Judge. Steve Engelhart. I had a kidney transplant, so I'm doing much better, but I'm still recuperating. But I didn't have it as bad as Mr. Knebel did, and I'll let Miss Vida tell you about that.
Yeah, Mr. Knebel has had major surgery because he suffered a fall and fractured, shattered part of his hip. So he's been out for more than a month now, and we hope sometime in June, maybe he'll be able to return for at least partial days. So sorry, we haven't been more aggressive on this, but both attorneys seem to have really had some struggles here.
So where does the case stand? Because this is what my thought is to get a scheduling order in place, if we can do that at this time. And I'm flexible on the trial date. You're hearing the trial dates, or we're talking 2026 for sure. It's just a matter of if we're talking earlier or, closer to summer.
I would ask that you push it back and give us a chance to either mediate the case or resolve it.
Would you like, rather than be placed on the trial docket, to have an order referring you all to mediation within, say, 90 days, or is that too short of a window?
Your Honor, what I would like to do is I believe that Mr. Knebel was trying to discuss this with our client to reach a resolution on this case. I think it can be reached perhaps without mediation, so I would like to have enough time to do that first.
So what I'm going to do with that is I am going to order mediation, but maybe open up the window a little bit, maybe say 120 days. So although I think 90 days, I mean, that should give you enough time to speak with your client and find out if you don't have to go to mediation or do anything. But we'll do 120, just frankly, in light of the court's calendar. I don't know if you heard the attorneys earlier, but we're going to be out of pocket for quite a bit of time in trial. So we'll do an order referring you all to mediation, deadline being in 120 days. I just know, where are you? Where are you all?
I am Judge Mr. Engelhart. I am in Houston.
Okay.
But the case is, and they're I believe in Dallas, aren't they?
Yes, we're in Dallas.
So generally, you all just agree to one if you are going to mediate, okay? And if there's an issue, I need to be made aware of that at least 60 days out of the deadline.
Thank you, Judge.
And then we'll just after the 60 days, Myrna, the first Wednesday the 60 days, after the 120 days, the first Wednesday, we'll do another scheduling status conference. If I've heard from you before then and everything's taken care of, or you have mediation scheduled, whatever it is, we'll find out then. And at that point, we'll see if we put you on a trial track.
Perfect.
Very good, Your Honor.
Okay, just know that, as we put this back, I know you probably are, optimistic that we're not going to go that route. It just kind of delays the timetable if we have to go to a trial. But I think you'll have your window. So unless something else comes up, I'm not going to ask you to come back until after you all have been talking. Okay?
Yes, ma'am.
Very good, Your Honor.
Have a good day.
Yes,
Thank
ma'am.
you so much.
Who's next, Mr. Nunez?
Judge, the only one I have waiting is Mr. Pierre, who
Okay.
apparently has left.
Who left? Who
Yes,
is
ma'am.
this? Who is Odukoya?
Mr.
Yes, Your Honor. I sent a message to your clerk with my case number. I have a status number. I have status call for 10:45, 11, and 11:15.
Okay, so the first one, 2625, is a scheduling status conference. And
Yes, Your Honor.
Carrie Murray, Mr. Nunez, do we have a Carrie Murray who has checked in?
No, ma'am.
Okay, let me go ahead and call that one because that one was at 10:45. Calling cause number 2024 DCV 2625, Bank of America NA versus Carrie Murray. May I have announcements, please?
Tomio Decoya for plaintiff.
And
Judge,
yes, ma'am.
I'm sorry if I may interrupt, just to let you know, Ms. Curry did notify the court that she's come to an agreement and she has a contract pending with the other party. She sent an email.
She sent an email.
That's an update to me, Your Honor. I don't know, pending that information, do we want to still just have a trial date just to have one, or do we want to take this off the I'll let you advise.
I'm not inclined to give you a trial date. What I'm going to do is reset you. It's either going to be about 2 or 3 weeks so that you can go back and find out if you all are squared away or if you want a trial date or what you're going to do. I mean, do you have any notation about any type of agreement that you all have come to with Ms. Murray?
No, Your Honor, and to be frank, I'm a parent to counsel, and a lot of times we're the last person to find out. So I'm fine with your ruling on that one.
That's why we're doing 3 weeks. Yeah, I think it's going to fall like 3 weeks out, but we'll just get you reset for just a status conference. Okay.
Thank you, Your Honor.
Thank you very much. Which one is the next one you have, sir?
The next one I have, last four being 2843. Portfolio Recovery versus Israel Reyes.
2843. That is 14. Thank you. Okay. Calling cause number 2024 DCV 2843, Portfolio Recovery Associates LLC versus Israel Reyes. May I have announcements, please?
Romeo Decoya for plaintiff, Your Honor.
Have we had any contact? I don't see anyone, or is there anyone appearing on behalf of Israel Reyes, or is
I can say that at least as far as the client goes, Your Honor, I'm showing that no contact, no answer has been filed. The defendant was noticed with service back on August 29, 2024, and I'm showing that the client is ready to proceed with a default judgment.
But I do have the motion for default filed as far back as October 2024, and the order setting hearing was sent out at the end of March. So I just want to confirm with my staff, we've had no contact from Israel Reyes?
No, ma'am.
You may proceed on your default, sir.
Thank you, Your Honor. In this one, Your Honor, this is a small debt claim. I'm showing the account originally being opened on November 13, 2020. The defendant last made a payment on April 18, 2022. The account was then charged off on November 28, 2022. Excuse me. Again, the defendant was noticed through posted service back on August 29, 2024, and has failed to file a response or appear in court. At this time, plaintiff is seeking a default judgment, Your Honor, in the amount of $2,510.20, along with cost of court. No post-judgment interest is being sought in this one, Your Honor.
All right.
Thank you.
Thank you. I have reviewed the motion with the attachments. The court will also take judicial notice of all the documents in the court's file and grant your request for judgment. I can't remember, I know I had some proposed orders, but if we haven't had it sent over, emailed recently, if you would please just send over the judgment and I'll sign off on it, okay?
No problem, Your Honor, will do.
Thank you.
If your clerk could put her email address in the chat, and then I'll make sure before the end of the day, I can send over that proposed order.
So it's her name. I see it in her name, but Myrna, if you'll put that in the chat as well. It's my.hernandez.
Yes, ma'am.
Thank you. All
Thank
right,
you, ma'am.
who's the next one?
The next one I have, Your Honor, Your Honor, ending in 2900.
Okay, and
Page
that I
14.
did see the drafted order, so that one is also set at 11:15. This is 2024 DCV 2900 Discover Bank versus Jennifer Paniagua. May I have announcements, please?
Tomio Decoya for plaintiff, Your Honor.
And again, I do not see anyone. Is anyone here on behalf of Ms. Paniagua? And if we received any contact from her, Mr. Nanez or Ms. Hernandez?
No, ma'am.
Okay, let me see.
No, ma'am, I don't have anything.
Thank you. All right, you may proceed on your default, sir.
Thank you, Your Honor. In this one, another small debt claim. I'm showing the account being open on March 25th, 2018. Defendant last made a payment on December 8th, 2023. The account was then charged off on February 29th, 2024. I'm showing that the defendant was served back on July 3rd, 2024, and has failed to file an answer or appear in court. At this time, plaintiff is seeking a default judgment in the amount of $28,221.29, along with cost of court. And in this one, the plaintiff is seeking post-judgment interest at the statutory rate, Your Honor, of 7.5%.
Sir, I'm seeing that your motion for default, there was one filed in 2024, but then I'm seeing another one that was filed 2 days ago. Just, you all filed it. What is the difference in the two motions?
I wasn't aware of one that was filed 2 days ago, Your Honor. I can get with the client and make sure that the correct proposed order has been sent to the court, and I can update with the email that I'm sending on the previous case, if that's okay with the court.
Maybe I can do it easily here. I'm trying to see if there's in terms of
Judge,
amounts. Monday.
there was an email sent on this one to you.
Yes, I saw that one. What
Okay.
I'm wondering though is if there is a difference from the 2024 motion, maybe in amount requested. Because if you're proceeding on the one that was filed, what day was it? Let me see. 2 days ago, then I'm not inclined to grant it. Just because we haven't sent this one out for notice. So, if Ms. Paniagua were to appear, this one was too close in time. But if they're identical and if you're abandoning your 5/19/2025 motion, I'm happy to go forward on the one that was filed in 2024.
I believe the one that I'm looking at is 2024, Your Honor. I'm showing that I can tell you the amounts on it.
Okay. Then based on that, I will accept. Did you finish everything on your default? Did you need to provide any more information to the court on the?
No, ma'am. I'm sorry. I didn't know if you were talking to me. No, ma'am.
Okay.
I'm done with presenting.
Okay. So on the motion for default judgment filed on October 16th, 2024, the court has reviewed that motion and considered all the attachments. We'll take judicial notice of all the documents in the district clerk's file, and I will grant your request for default judgment.
Thank you, Your Honor. And so that one doesn't need to be resent, correct?
No, I have that order.
I'll make sure I send the other one to the clerk, Your Honor. That's all I have before you this afternoon. May I be excused?
You may have a good day.
Thank you, ma'am. You too.
Let's quickly call the remaining cases that are on page 14. Is anyone in the waiting room on these cases, Mr. Nanez? All right, this is cause number 2024 DCV 2850 Goldman Sachs Bank USA versus Charles Ponce. May I have announcements? No one appearing for today's hearing. It was set for status dismissal. This case will be dismissed for want of prosecution. Next case is 2024 DCV 3018 Midland Credit Management Inc. versus Joel Garcia. May I have announcements, please? Again, no one having appeared for this hearing. It was set for status dismissal. It will be dismissed for want of prosecution. Next, 2024 DCV 2885 Discover Bank versus Annabelle Miranda. May I have announcements, please? Again, hearing no one appearing today for today's hearing, set for status and dismissal. This case will be dismissed for want of prosecution. Lastly, on page 4, 2024 DCV 2764 Discover Bank versus Victor Diaz. May I have announcements, please?
Judge,
Monday.
on that one, they sent you an order of non-suit.
Okay. Non-suited. All right. I did get everyone now except for the Mr. Pierce case. What happened with the one on page 3, 3788?
Judge, I called Miss Hale's office and left a message. They have not returned my phone call.
Has anyone appeared on that case?
No, ma'am.
Okay, let me check that one. Myrna, do we have any correspondence? Oh, there's a non-suit. Is that to everyone? Plaintiff's notice
Let
of
me check on that, Judge. I don't recall that one.
It looks like there's a non-suit on May 8th. But let me see. Pursuant to all claims and causes, it was non-suited. So we need the order. Okay, let's bring in the remaining parties on Pierre.
Yes, ma'am.
Pierre.
It's going to Miss Mary Aguilar Felix. Mr. Pierre has left the waiting room and logged off. I did speak to him when I brought him in earlier, and I spoke to him and I asked him to wait, and I explained it would be a while.
Okay. Let me see, is Miss Aguilar on? Okay. Calling cause number DCV 0542, France Pierre versus Claire Shamblin Caton et al. May I have announcements, please?
Your Honor, Hector Beltran on behalf of the named defendant, Mary Aguilar.
Okay.
Your Honor?
Yes. Who's that?
I'm sorry. There is an email that Mr. France sent asking to reschedule the hearing. I just sent it. I just forwarded that to you.
Well, that's in line with what I was just thinking because just for the record, Mr. Pierre was logged on and we had several matters that preceded this case. We were set basically just for a scheduling status conference to set a trial date. So Mr. Beltran, I don't know if have you all conferenced at all about scheduling this further? We have. Bear with me.
Your Honor, I've attempted to talk to Mr. Pierre to kind of gauge what he's trying to do, and yeah, I mean we just haven't had time to do it. We're likely going to file an interpleader. The money he's complaining that we have, we're probably just going to tender to the court and let the chips fall where they may. My client shouldn't be part of this case. His claims against her are convoluted, contrived, impose on her duties as if she's. I don't understand what he's doing. There is an actual deed that he signed transferring title, that it actually says the purpose of this deed is to vest title in my name and in his wife's name. It's almost laughable where we are in this case. But my client is being forced to spend money to defend herself, and we're going to have to defend her. I was hopeful that we could figure out a way to provide something for Mr. Pierre so he'd let my client out, but that isn't going to happen. And so we're going to have to start swinging back and defending. And it's just where we are. And we're likely going to start by challenging his affidavit of inability to afford to pay costs, because missing on there is the property that he claims he owns in his own name. His own separate property does not appear on his affidavit.
Let me stop you right there, Mr. Beltran, because I do feel that it was on the court to have this proceeding start. So you all were set at 10:30 and it is now almost 11:30. And
right.
So I don't want to hold that against him because he did appear, but I do want to set this at a time where it is not put together with all of our regular caseload. So I want to do it on June 11th. At 8:30 a.m. via Zoom to get us away from the regular civil docket and have enough of an opportunity, I guess, to have a useful discussion of a status. So I'm just setting it for status. What I will say is that, so it'll be a status conference, scheduling status conference on Zoom. What I will say is this, however, if there is something that is timely filed for which that date is useful to have anything heard, happy to do it. That's
Understood.
okay. Okay. Thank you, Mr. Beltran. I'm sorry to keep you waiting.
No problem. Thank you.
Have a good day. Miss
Bye-bye.
Simon, are you there?
Yes.
Oh no, Miss Aguilar, you're good to go. I'll refer you back to Mr. Beltran.
Thank you.
Thank you. Miss Hegeman, can you hear me? Do we know why she's logged in, Mr. Nunez?
No, I spoke to her for a little bit and she said she knew she was early and she was just gonna stay logged in.
Oh, cute. Okay. Bueno, pues, I don't know if you're gonna leave the Zoom open, but is that everybody today? Is there
On-
anybody else I need to call because they didn't appear?
On page 2, Judge,
Mm-hmm.
on the second to the last.
2606, let's call
Yes,
it.
ma'am. I did contact the attorney. I called the attorney. There was just rang when they leave a message.
Calling cause number 2024 DCV 2606, Stephen Walter Strotter Jr. versus Jose Alfredo Arieta. May I have announcements, please? Mr. Nunez, I understood we were speaking briefly off the record. Had you made contact with plaintiff's counsel?
I did contact the real estate phone number, Judge, and I received no answer on the line.
Okay, and they were at any point, did someone appear?
No, ma'am.
All right. It looks like this was filed back in May 2024. Hearing a notice was sent. Christian, can you tell me if they opened the email with the order setting hearing for today's status?
Yes, Judge, let me check that for you.
Thank you.
Judge,
Monday.
just a quick question on page 14, on cause number 2885, second to the last on that page, there was a motion to retain. Was that granted? I'm sorry, I didn't hear.
No, dismissed. That's not granted and it was dismissed for failing to appear today. Gracias.
That was that same gentleman that covered the other ones, Judge.
I looked at the name, he was excused, and when I called it, I saw his name, but he didn't say it.
Okay.
He didn't say he was here for that one.
Okay, Judge, so I'm looking at it,
Mhm.
and Attorney Eduardo Diaz Posturakis, it says not open.
Not open? All
Yes,
right,
Judge.
thank you. So that case is going to be dismissed for failing to appear today. Another DWAP. Okay, are there any more pending?
Judge, on page 3, the second to the first, to the second to the top,
Mm-hmm.
3788,
That's
Dwayne
the one
Johnson.
that I think, did we get a confirmation that it was non-suited, the Dwayne Johnson one?
I need to request that order from them, Judge.
Okay, so that's a non-suit, Mr. Nunez.
Yes, ma'am.
We just need the order. What about 2738 Socorro Aranda?
That's a non-suit, I believe.
Okay.
No, I don't have that.
I'm sorry, I saw the wrong one. 2738.
Bottom of page 3.
No, Judge, I don't have, let me check.
Let me pull it.
2738. That was the one with Miss Hale, Judge, and I contacted her and left a message. They did not pick up.
So wait, you said Miss Hale earlier, so who are we talking about on that one?
2738
Uh-huh.
is on bottom of page 3. That's who I called, Judge, Miss Hale.
Okay. All right, calling cause number 2024 DCV 2738 TD Bank USA NA versus Socorro Aranda. May I have announcements, please? Okay, this case was filed back in June of 2024. Order setting hearing was sent out March 24th, 2025 for today's status conference. Again, Christian, I'll ask you on this one as well. Can you double check if the notice it was opened?
Yes, Judge, so I'm seeing that it was open on March 24th, 2025, both from a what's it, RSIEH Texas and ABC Legal Dallas.
Okay, so they have received notice and they are not appearing today, so the case will be dismissed for want of prosecution. Another D1. Unless, did someone check in, Mr. Nunez? Did somebody? Anybody? No?
No, ma'am.
Okay, so that one's dismissed as well. Are there any others?
I did not catch what we did with page 3, top case 2625.
Okay, let's go ahead and get off of YouTube if we're not getting on the record for anything else.
Yes, ma'am.